Good morning. Can everyone hear me okay?
Uh, I can, Your Honor.
Yes, I can.
Yes, Judge.
Okay. Do we have everyone here? Or do we need to wait on someone else?
Uh, I think it's everyone from plaintiff's side that needs to be here. One or more of my associates may get on to watch, but we don't need to wait for them.
Um, are we going to have a record? Were you informed that we don't have court reporters in the associate judges' courtrooms and you need to provide your own reporter if you need a record? Were you informed of that?
We were not informed of that, Your Honor.
Do you think you'll need a record in this particular hearing?
I don't think so, Judge.
I can see if I can find one if you do. I can't guarantee we'll get one at this late date, but if you'd like for me to try, I will.
No, Judge, I think it's best to just proceed.
Okay. Well, we're a little early, a couple of minutes, but that'll work to our advantage. First of all, I want you to know that I have read the file. I understand most of the basic facts of the case. I've read the motion, I've read the responses. So unless you need to regurgitate some of the facts to augment your argument, assume that I understand some of the basic facts. And we'll get started. We're here on cause number DC 2204312. It's a case down Mid-American Mortgage, and there are several defendants, and I think the pending motion today has to do with defendant Grubbs and Cooksey, I think. Is that correct?
Yes, Your Honor.
Okay.
Yes.
All right, the movement, you may begin.
Thank you, Judge. I'm Shane Kotlarski. I'm here on behalf of Brian Grubbs and Mike Cooksey with my co-counsel, Mr. Conley. Your Honor, I just want to clarify as well, did you receive and review the reply that was filed by defendants on Friday?
I did get that. Thank you. Yes.
Wonderful. All right. So then I'll just cut to the chase, Judge. There are three things the court is going to be looking at in order to determine whether to grant a continuance of the hearing on plaintiff's partial MSJs in this case. Those three things are the time that the case has been on file, the materiality of the discovery sought, and the diligence with which the movement has sought that discovery. So I'm just going to run down each of those factors, Judge. Mr. Grubbs and Cooksey filed their counterclaims on October 31st, 2022. On January 30th, 2023, so that's 3 months later, plaintiff filed its partial motions for summary judgment as to the claims against Mr. Grubbs and Mr. Cooksey. About 2 weeks later, plaintiff set their partial motions for summary judgment for hearing. That hearing is scheduled for March 24th, 2023. So even though Mr. Grubbs and Mr. Cooksey are the movants, the party seeking affirmative relief in the counterclaims, we still have not had an opportunity to do any discovery with regards to those counterclaims other than written discovery, I should say. So as Your Honor saw in the pleadings, we have sought written discovery from plaintiffs on issues directly related to the counterclaims filed by Mr. Grubbs and Mr. Cooksey. And discovery has been a slow slog in this case, Judge. We continue to get representations from plaintiffs' counsel that they will amend their discovery, they will produce additional documents, they are going to do it on a rolling basis. So we continue to get discovery from them, we continue to get documents, but there are still several issues on the discovery that a court is going to have to take up as on a motion to compel. And I do want to point out, and I mentioned this in the reply, Mr. Callahan argued that, well, if discovery weren't an issue, why have defendants not filed a motion to compel yet? And I think that if we had filed a motion to compel, Mr. Callahan would have said, we're talking, and a motion to compel is too early. I'm giving you documents. So he can't have it both ways on that, Judge. But regardless, 3 months between assertion of the counterclaims and filing a motion for summary judgment is just not a sufficient time, and that factor weighs in favor of granting a continuance. And as to the materiality of the information sought, there are 2 claims at issue in the motions for summary judgment: the breach of contract counterclaim brought by Mr. Grubbs and Mr. Cooksey, and the unjust enrichment claims. As I mentioned earlier, and as we laid out in the briefing, Mr. Grubbs and Cooksey have sent requests for production on those claims, but have not received full, complete discovery, if any documents responsive to those requests. But the issue here, I think, is a misunderstanding or misrepresentation of what the claims are and what should be done with them. Because in the unjust enrichment claim, the issue is not about the specific compensation that was owed to Mr. Grubbs and Mr. Cooksey under their employment agreements. And defendants acknowledge that the Texas Supreme Court has said that where there is an express contract between the parties and the same subject is covered by that express contract, that an unjust enrichment claim is barred. But we don't have the same subject. The contract has to unambiguously cover the subject matter of the party's dispute. And Your Honor can find that in the Fortune Products case, that's 52 Southwest 3rd 671. That's a 2000 Supreme Court opinion.
What's the name of the case again?
I'm sorry. Fortune Products, 52 Southwest 3rd 671.
It's cited in our response, Judge.
Okay, where in your response is that?
It is cited on page 4 towards the bottom. Next to last line.
On page 4 of your response, of plaintiff's response?
Yes, Your Honor.
I got it. All right, thanks.
And Your Honor, as defendants pointed out in page 3 of the reply, in the GRC Dallas Holmes case from the Fort Worth Court of Appeals, the contract must unambiguously cover the subject matter of the dispute. Mr. Callahan has argued in the response that all that there has to be is intertwining of the issues, but that's not what the Supreme Court said in the Fortune Products case, and not how the GRC Dallas Holmes case takes that and makes a finer point on it. Because what Mr. Grubbs and Mr. Cooksey are complaining of is that by Mid-America taking a number of actions, not complying with regulations X or Z, violating state and federal laws, it's not that they withheld compensation to Mr. Grubbs and Mr. Cooksey, but rather that Mid-America enriched itself to the detriment of Mr. Grubbs and Mr. Cooksey. If I may, Your Honor, I can. It's not that. So Mr. Grubbs and Mr. Cooksey both received money based on the loans that were placed with Mid-America. They were commissions, essentially. Mr. Grubbs directly for the loans that he and his group placed, Mr. Cooksey based on his group's profit, the branch's profit. And we're not saying, Your Honor, that as a result of Mid-America violating these regulations, that there was a loan that Mr. Cooksey did not receive, or Mr. Grubbs did not receive credit for, or that they received less than they were supposed to, but that Mid-America enriched itself to the general detriment, to the detriment of Mr. Grubbs and Mr. Cooksey. But regardless, Judge, I think this is a question about, that's a question about the merits of the summary judgment. And it's for, you know, we're here on the motion for continuance. And so the question is about what's the materiality of the information sought. And Mr. Callahan can argue, as he has, that he thinks that the Fortune Products case applies, but Mr. Grubbs and Mr. Cooksey are entitled to discovery to pursue their claims, and they have asked for discovery about that goes directly to the questions on their unjust enrichment claim. And I do want to point out again, Judge, not a single deposition has taken place in this case. And that's not because the parties have been derelict in their duties. It's because we don't have the sufficient documents to take a deposition. How am I supposed to ask some corporate representative from Mid-America questions about Mr. Grubbs and Mr. Cooksey's unjust enrichment claim when I don't have documents that may go to supporting that? As to the breach of contract claim, Judge, in Mid-America's response to the motion for continuance, it says that Mid-America is clarifying not what it says in its motion for summary judgment, but just it wants a determination that the contracts, the employment agreements, do not mention regulations X or Z, and that Mr. Grubbs and Mr. Cooksey do not have a private claim under either regulations X or Z. Neither Mr. Grubbs nor Mr. Cooksey is bringing a claim on those actions. They are saying that because Mid-America violated those regulations by, for example, transitioning a loan from a individual loan to a branch loan, or reducing the interest on a loan in order to stay competitive, things that directly did affect Mr. Cooksey's and Mr. Grubbs' commissions, that as a result of those actions, Mr. Grubbs and Mr. Cooksey did not receive the compensation to which they were entitled under the contract. And I think that that clarification is important, because in the motion for summary judgment, plaintiff argues that we in fact complied with the employment agreement. We paid Mr. Grubbs a bunch of money, we paid Mr. Cooksey a bunch of money. Here's an affidavit saying we did that. But they don't attach any of the documents that support.
Okay, Mr. Claude, let me interrupt you 1 second here. As I understand the partial summary judgment motion, it's fairly limited as I understand, okay? And can you address those issues that would require you to continue the hearing that you don't have the discovery to respond to?
Yes, Your Honor. I apologize if I was getting too into the weeds on the motion itself, but as to the breach of contract claim, the issue is that we have sought discovery on all of the loans that Mr. Grubbs placed, or his group placed, for which he would receive commission. That is how his compensation was determined. We have asked for information on the profits of the Cooksey branch, which is how Mr. Cooksey earned his compensation. Plaintiff has not produced those documents, and as a result, we have not been able to take a deposition of someone from Mid-America to say, okay, if we look at this loan agreement, how did Mid-America calculate Mr. Grubbs' commission based on this? Or what did Mid-America do when it changed the terms of the loan to reduce Mr. Grubbs' commission? We're entitled to see every one of those loans that was placed in order to substantiate the claim for breach of contract, for example. And so what Mid-America is essentially saying, Judge, is because Mr. Grubbs and Mr. Cooksey do not have private claims of action under regulations X or Z. They cannot sustain a breach of contract claim, but that's throwing the baby out with the bathwater. That's, this small issue as to the breach of contract claim and doesn't go to the heart of the matter. I hope I answered Your Honor's question, but I'm happy to.
Well, I'm sorry to interrupt you. I was just trying to narrow down your request here. As I understand it, you've got a partial summary judgment motion that's going to be heard on the 24th of this month. And you're
Correct.
asking for a continuance.
Correct.
Basically, as I understand your motion is that you haven't had the necessary discovery to develop those issues to respond to the summary judgment motion. So my
Correct.
question was, as I understand the motion is fairly tailored and narrowed to only some very specific areas regarding the breach, regarding the unjust enrichment, and a third, I can't remember it right now. So I wanted to get your response to those narrowed. I understand you don't have all these depositions. It's kind of a shame, though. This case is a year old and you haven't even had depositions yet. And you're still having issues of discovery, and you haven't brought that back to the court to resolve. But even so, I want you to kind of narrow down this motion for continuance, why you need this continuance to address these three narrow areas that the plaintiff is asking for a summary judgment motion on.
Do you mind if I address this point, Shane, Your Honor?
Go ahead, I don't care.
Go ahead, Mr. Conley.
Thank you, Your Honor. John Conley. I'm with the law firm of Lewis Brisbois. I'm in Akron, Ohio, but I pro-hawked into this case on behalf of Cross Country and Mr. Grubbs and Mr. Cooksey. So there's the three causes of action that Mid-America would like to excise from this case. The first being a breach of contract action that they characterize as being rooted in violations of these two regulations that are pertinent to the mortgage industry. That there's a miscommunication there. The breach of contract causes of action are about their taking commissions that they should have paid and not paying those commissions. Now, the behavior also violates Regulation X and Regulation Z, and that's noted in the counterclaim. But we're not suing for a private cause of action based on violation of those regulations. And the reason that that's important is I don't think that there is more discovery to be done on whether we are seeking to enforce a private cause of action under Regulation X or Regulation Z.
Let me interrupt you 1 second, Mr. Conley.
Yes, sir. Yes,
Tell
sir.
me what your counterclaim is for breach of contract.
Yes, Your Honor. The breach of contract cause of action is rooted in the contention that in their contracts, these individuals have commission levels that they should be paid on each loan that they originate. Now, if they originate it individually, meaning from one of their connections in the industry, then they should get 150 basis points as their commission. If it's a company generated or branch generated loan, then they only get 50 basis points. They literally get 2/3 less of the commission. What Mid-America Mortgage was doing was taking their self-generated commissions, agreeing to pay them that rate, which they're obligated to do under their contract, and then late in the game, when the consumer would try to negotiate, Mid-America would come to the loan originator and say, we will fund this loan, but only if you now accept the lower commission, the non-contractually obligated commission. And they would put these loan originators into a position where it was either fund the loan and take the lower commission or get no commission at all.
Okay,
And
let me interrupt you on that point. I haven't
Yes,
read the actual contractual relationship between your client and Mid-America, but is there a provision in the contract relationship between the employee and the mortgage company to make that change?
No, they're not permitted to make that change. There's nothing in the contract that contemplates that.
All right, go ahead. I'm sorry to interrupt you. Go ahead. Okay.
Yeah, and in fact, it's against the law. And that's the reason that things are getting confused, because we note in our counterclaims that they are violating these regulations by doing this behavior, but they are taking that to mean we are trying to prosecute a private cause of action under those regulations. That's not it. We are showing that you breached the contract, the commission provisions, and by doing so, you violated these other regulations that are controlling in the mortgage industry, no question there. But it's not a private cause of action. So that one could, one second. Apologies, Your Honor. That one could be disposed of at this summary judgment hearing. It's a nonsensical argument because it doesn't squarely meet the actual allegations in the counterclaim. So that's an easy one. But the fear here, from our perspective, Your Honor, is that what they're trying to do, and we are going to file motions to compel. It has been inevitable. I have been trying time and time again.
Okay, I got you there. Let's continue to go to these counterclaims.
But the concern is that our breach of contract cause of action is, we are seeking information related to the commissions paid on all of these loans that should have been paid at full commission and weren't, and that is the information that we have been precluded from having.
Let me ask you this, let me interrupt you.
Yes, sir.
Can you provide affidavits and respond to the summary judgment motion regarding those issues?
Regarding the commissions paid, it would be impossible. They have possession of all of the data that we need to be able to make our breach of contract damages arguments.
Okay,
and
that's not what I'm asking. This is what I'm asking. These individuals knew what the contract calls for them to be paid on certain commissions on certain trades, right?
Yes, sir.
And they got less than that, right?
They did.
Okay. So my question is, can you present an affidavit in response to bolster your breach of contract claim that said the contract said we were supposed to be paid this way and we were paid this way? Would that be adequate response to the summary judgment motion in light of continuing the hearing until you can get additional discovery?
Mr. Conley, you're on mute, but...
Apologies. So I think the short answer to your question is absolutely, our people are going to testify, and they could do so in affidavits to this structure of the breach of contract. The problem would be that we're unable to substantiate it monetarily and put flesh on the bones of those claims.
Well, all you gotta do is present a question of fact. Mm-hmm. I'm not asking you to develop what this breach of contract is. If you can show the contract says this, and your people can sign an affidavit, and this is what was paid, that's a fact issue for me. Okay? So I'd be really in a bad position to grant a summary judgment motion if you got a fact issue provided by or substantiated by an affidavit. I guess the question I'm trying to get to, when I read your motion, my initial response was that you couldn't respond to the summary judgment motion because you hadn't gotten discovery. Okay? And that's why I'm trying to pin you down to the narrow areas that the plaintiff has filed his summary judgment motion, and to see if there's ways you can respond. And I think it's probably important that you get these heard, because, like I said, you got a year-old case here and nothing's done. So I'm trying to figure out if there's a way we can still move forward. And if we can't, I understand. I'm not trying to say we have to move forward with the hearing, but I'm trying to show, is there other way you can respond? And you don't
Judge, may I respond?
Go ahead.
Two things. One, it is true that Mid-America filed this case in late April, but they sought an injunction first. The first 3 months of this case were dealing with the injunction. It was not until July that Mr. Cooksey was even added as a party. That being said, Judge, I think the relevant time frame is from the date of the counterclaims, end of October.
Understood. Okay. I'm trying to resolve.
Your Honor,
wait a minute. Stop interrupting me. Let me interrupt you, but don't interrupt me. I'm trying to get to the crux of this motion.
I understand.
You're saying you need some more time to effectively respond to a partial summary judgment motion. And I'm trying to understand why you need time to do that. We've already identified that the partial summary judgment motion regarding the breach of contract you can provide credible summary judgment motion to defeat that, from what I understand. So what I want to do, I want to go through the others, okay? And then I'm going to give Mr. Callahan a chance to respond, okay?
Your Honor, if I may still,
Go ahead.
yes, we can provide an affidavit saying that these individuals were not paid in accordance with the contract. But we have no other evidence that we can provide to substantiate the claim that to defeat the motion for summary judgment.
Well,
as
the contract says what it says. If they were paid one way and the contract said they should have been paid another way, an affidavit and the contract, I think, creates a fact question. Would you agree?
Respectfully, Judge, I believe there's more that's needed.
Of course there's more. All you have to do is determine if there's a fact question that still exists. Of course there's more. No one's going to ask you to present your whole counterclaim at a motion for summary judgment issue, a hearing. That's not what I'm saying. All you have to do is say, hey, we've got a breach of contract counterclaim, and this is why we think we've got it. There's a fact issue. I've got the contract that says this. This is how my client was paid. That's a fact issue. That's something a jury can determine. I'm not going to grant a motion for summary judgment if you've got a fact question. And that's what I'm trying to get to. I'm not trying to try this case today, guys. I guess I'm trying to get to the point of show me why we got to continue this, that you can't resolve it another way. Okay,
Yeah,
let's move on from the breach of contract. I think I understand that. Okay, what's the other counterclaim by which the summary judgment motion is a subject of?
there's two other counterclaims, Your Honor. The first is a claim for overtime compensation for Mr. Grubbs under the FLSA. The plaintiff's argument hinges on the contention that Mr. Grubbs is a exempt employee, and we don't agree with that, and we think there's issues of fact with respect to that too. But of course, we're asking for information about his submittal of timesheets that they haven't provided, about his information about his team's submittal of timesheets, which they haven't provided. There's certainly information in his contract that says that he's not allowed to get overtime unless he asks for it in advance. So we were asking for any information about him asking for things in advance. And so far, we've gotten none of that information about Mr. Grubbs. So we understand that it's their contention that he's an exempt employee. We're seeking to gather information that shows that he's a non-exempt employee and they treated him as such. And we haven't gotten that. So we'd like some time to get that.
Okay, gotcha.
And
What's the third one?
the third one, Your Honor, is for unjust enrichment. Mr. Grubbs and Mr. Cooksey both have unjust enrichment claims, and the plaintiff's primary argument there is that there's employment contracts that control here, and because there's employment contracts that control, the unjust enrichment cause of action is excluded as a matter of law. The problem there is that there is more to this story. For instance, Mr. Cooksey was a branch manager, and if you'll forgive me for diving into the facts for just a second, Your Honor, but Mr. Cooksey, who was a branch manager, he entered into negotiations to buy Mid-America. Everybody agrees to this. Mid-America told him they were going to give him numbers. He exchanged different confidential information with Mid-America to further those contract negotiations during his employ. On Friday, he was told, we're going to get you final numbers. On Monday, Jeff Bodie, the owner of Mid-America, came in, fired Mike Cooksey, and then told all of his team that he had moved on and that they were all being sold to Legend Lending, a new employer. So it's in those misrepresentations, it's in those actions that Mr. Cooksey's claim for equitable relief root. The claim that he was mistreated in the course and context of how he was handled in these contract negotiations, and then how he was fired. We've asked for emails about those contract negotiations. Mr. Callahan has told us that he agrees that those are discoverable and he's going to provide them, but I don't have them. I've never been able to review them. I know they exist. There's no way that a business decision of this magnitude is made without some correspondence between the parties, emails and text messages, but those have not yet been given to me. So from Mr. Cooksey's perspective, he would like to have the evidence about the discussions about how he was treated in the course and scope of being recruited to MAM, and then how he was treated with respect to how he was separated from MAM. Mr. Grubbs has an unjust enrichment claim, Your Honor. That claim is again rooted in the business torts, negligent misrepresentation, fraudulent misrepresentation. Essentially what they did is they told Mr. Grubbs, come work for us. We'll take all of your contacts, we'll upload them into our system, and then we'll use them. But we'll never try to take them from you. Those are your customers, Mr. Grubbs. So if you come work from us, you keep your customers. Those were material misrepresentations that were made to Ryan Grubbs to recruit him to come to this firm. Well, as it turns out, when they fired Mike Cooksey and then everybody decided to leave at the same time, they have now turned on their heels and they're claiming that information that Mr. Grubbs brought to the company actually constitutes the company's proprietary trade secret information. The discovery that we've sought on that point, Your Honor, is emails and text messages and other documents that Mr. Grubbs brought with him to the company and provided to the company when he joined, and information about how the company treated other individuals in the course of cutting them loose. I have been told that those emails exist. Mr. Callahan has not represented that he's going to provide them to me, but he said something to the effect of, it will take us weeks to gather them and weeks to review them, and then we'll get you whatever is relevant and discoverable. That's sort of, it doesn't help me, and I have not seen those emails, but those are the two primary thrusts of Mr. Grubbs and Mr. Cooksey's unjust enrichment claims that are rooted in issues that are not detailed in the provisions of their written contract. So those are the issues that we're seeking more information about, and in fact have been promised that we would be provided more information about. We're just sort of waiting to get it.
Okay, let me hear from you, Mr. Callahan.
Thank you, Your Honor. And while they were talking, my computer went spastic and I lost y'all for a couple minutes. So if that happens again, I'll get back on as soon as I can. I'll try to be brief. I noticed that when I try to share screen, I get a message that you've disabled it. Can I ask you to enable it? Because I think I can help walk you through what I'm saying if you do.
Okay. Okay, you should have the privilege to share your screen.
I do. This is just a summary of some of the information that's in the papers that are on file with you, Your Honor. The defendants have asserted 7 counterclaims. Breach of contract, Grubbs FLSA claim, an unjust enrichment claim, fraudulent inducement, negligent misrepresentation, fraud, and Cooksey has asserted a counterclaim for conversion. My motion is only addressed to the top 3 that are in red on here. All the discussions Mr. Conley just went through about having been fraudulently induced or misrepresentations, those claims are going to be alive, even if my motion for summary judgment is granted. I'm going to try to avoid going into all the merits of the motion and merits of the discovery dispute, because I don't think that's what we're here for today. They filed a motion to continue a hearing on a motion for summary judgment. And Rule 166AG has very specific requirements about what they have to do to get that. They have to come forward with affidavits that say and explain why they cannot present what they need to be able to present to justify their opposition. And Mr. Kotlarski's declaration filed with the motion is the only one they've filed, and it doesn't do that. All it says in paragraph 4 is plaintiff has failed to produce relevant documents to date, and they've been unable to take depositions of relevant witnesses. They're entitled to discovery to support their counterclaims. And this goes back to a point you made, Your Honor. I'm not asking for summary judgment on all their claims, and they don't have to be able to prove their case to be able to create a fact issue. They have to explain why neither Mr. Grubbs nor Mr. Cooksey nor anyone else can execute an affidavit that would enable them to respond. And first of all, they haven't done that. So I think you should deny the motion on that basis alone. On the second ground, as I went through my in my response, I purposefully did simple, targeted motion for some partial summary judgment because this case is spiraling out of control and we need to focus it on real claims. It's kind of analogous to people that try to fracture legal malpractice claims and bring fraudulent misrepresentation, GTPA, when it's really a malpractice claim. They want to claim fraudulent inducement, they want to claim negligent misrepresentation, that Mr. Carney went on and on and on about. I haven't addressed those claims in my motion. My FLSA claim against Mr. Grubbs is simple. It says he was a highly compensated employee who had compensation in excess of the Code of Federal Regulations, and he was a management employee because he managed teams. The summary judgment evidence has his W-2s for the last 5 years on file, which shows that he was paid over $5 million. Now, all he has to do to create a fact issue on that is sign an affidavit that disputes what he was paid or disputes what his responsibilities were. Clearly, he knows what he was paid and he knows what he did. They don't need discovery to be able to respond to that. If they think there's a legal problem with my argument, that regulations don't say what they really say, they should be interpreted differently, that's a legal question. They don't need discovery to address that. On the breach of contract claim, I think Mr. Connolly pretty much acknowledged they don't need discovery to respond to that. Their position is, my motion didn't address everything in their claim. Well, I can't get summary judgment if I don't address their claim properly, and that's a pleading question. They don't need discovery on it. The existence of the contract, which is in the summary judgment evidence, and one of them is attached to their motion, is the fact. The mere existence of that contract is what gives us an entitlement to summary judgment. Now, if they're not going to dispute the existence of the contract, and it comes down to what does the language mean, they can file an affidavit, maybe, depending on what it says, as to what their understanding of it was and why they thought it was breached. They don't need discovery for that. And one perfect example of why we need to start cutting through these claims is if you look at page 4 of their motion on the breach of contract claim, towards the bottom of the first paragraph, they make the statement that the violation of these statutes we've been arguing about rendered the contract void. For the life of me, I don't understand how someone can file a breach of contract action if at the same time they're saying the contracts are void. We need to just start cutting through all this nonsense. And if I didn't address their motion properly, their claim properly, they can do that. If they have a position about how it was done or what they thought it was, they can file affidavits. They certainly have not explained why they can't. And that's the unjust enrichment claim. I mean, the breach of contract claim on my motion on page 2, I summarized what they pled. That demonstrative aid got lost when my position went spastic, but they go through paragraphs 130, 132 of their counterclaim, what they're suing us for. I think I've addressed it. If I'm wrong, they can respond to it. I mean, the point of this hearing is that there is no need for them to take discovery to address fact issues, to be able to bring forward fact issues. I mean, I filed this motion on January 30. They filed the motion to continue on February 22. They argued their motion for half hour. I still have not heard the name of one single individual they claim to need a deposition of to respond. It's just, oh, I need to take a whole bunch of that discovery to support my claims. Not the time where they have to support their claims. They just have to create a fact issue. And as I think you properly observed, they're in the position to be able to do that without any more discovery, so I would request that you deny the motion.
May I reply briefly, Judge?
Please.
As to the argument about 166AG, I pointed out in my reply that you can move for a continuance under that rule, or 251 or 252.
Okay, let me tell you. Right now, what I want you to focus on
Yes, Judge.
are those 3 counterclaims
Sure.
and why you need discovery to present a fact issue that would defeat a motion for summary judgment, okay?
Understood.
That's
So-
why, I think that's the key to what we're here for today.
And I tried to say this earlier, Your Honor, and I did not do so as articulately as I had hoped. But the Supreme Court has held that an affidavit opposing summary judgment must present some probative evidence of the facts at issue. Conclusory statements are insufficient to defeat summary judgment.
I understand that.
So if we present an affidavit in response to the breach of contract claim that just says, I, Ryan Grubbs, believe that I was not paid the sufficient amount because the loans were transitioned to a group loan or the rate was reduced, without evidence to support that contention that he believed happened, Mr. Callahan can move to...
Okay, I'm not suggesting you present that kind of affidavit. That was no way what I was referencing.
I apologize,
I'm
Your Honor.
saying you've got a contract. Submit your contract, submit an affidavit. I'm John Doe. I closed this particular loan on this date for this amount. My contract says I should have been paid this much. I was paid this much.
We cannot do that at this time, Your Honor.
There's no
Okay,
affidavit
wait.
that says that, Your
Wait a
Honor.
minute. Why can't you do that?
Because we do not have the information about the specific loans that were closed and the terms on which those loans were closed.
No. You know what the contract said your client should have been paid on X amount of loan, right?
Correct.
And your client knows how much he was paid.
Correct.
If that is in contradiction of a contract, that's a breach of contract in my mind, and definitely if it's a fact issue. Okay. So the notion that you cannot generate an affidavit in a week or so that would create a fact question, I'm kind of concerned that you think you can't do that. I don't know why you can't do that.
Well, Your Honor, because the only thing that the affidavit could say at this time is there are several loans, the identity of which I do not know, that I was not paid the correct amount on. And that's not enough to create a fact issue without
Okay,
proof.
I'm going to disagree with you, okay? If I'm John Doe, I close the loan of X dollars, I go back to my contract and it said I should have been paid X dollars, and I was only paid X minus dollars, that's a fact issue because my contract said I should have been paid this, okay? And I don't think you got to go through his whole portfolio of loans. I think if you just generate one, that's a breach of a contract to me. That's a fact issue. That's something the jury's got to decide, okay? Let me ask you to respond to what Mr. Callahan said earlier, okay? He's saying that these employees are exempt from from SLL. FSLA. What's your response to that?
The factual response, the response would be that there's evidence that suggests that they're not. There's
Okay.
reference to that, yeah.
What's that evidence?
The evidence that I have at present would be the fact that they made him sign a contract saying that he must get permission before he is paid any overtime, which tends to suggest that they did not view him as an exempt employee. And they had him submit certain documents that I know about, but I have not been provided, that tend to suggest that they were seeking information about his investment of time on a weekly basis from a should we be paying this guy overtime perspective. And I appreciate, Your Honor, that we can provide affidavits that say these things. I think part of the friction here is that we're being stonewalled on the ability to create a compelling case with the evidence that exists And we can provide affidavits, and we can likely defeat these summary judgment motions on the affidavits, but we're being stonewalled on the ability to present the court with a compelling case about what our case is about. And so I think there's evidence that Grubbs was not exempt. I think we have some of that evidence in our possession, but I think we've been stonewalled on the bulk of that evidence that's in Mam's possession. And I would prefer to submit a contrary motion in opposition to their summary judgment motion that was robust and fulsome. I know we don't have to prove our case, but I would like to show the court exactly what I'm talking about rather than rely on being able to sort of create an issue of fact with an affidavit when I know that the evidence exists and I know that they have it and I'd like to have it in my possession. But that's it on that one, Your Honor.
Well, I think we've got two issues here. We got one issue where we've got a motion for some summary judgments on some issues that I think you can create a fact issue on, just from our short conversation today. You've got a separate issue that you haven't been able to get the discovery you need to develop your case. I think they're two distinct issues.
I agree, Your Honor.
Let me see if I can cut the baby in half here. Just quickly, Mr. Callahan, how would you respond briefly, just real briefly, to, I know they said they could have filed a motion to compel and they haven't. How would you respond to their allegation that you haven't been forthcoming with discovery responses?
I deny it. I mean, as I said in my response, we've produced 4,700 documents. We're arguing about more, but I've produced what I think they've entitled to. The argument is they've asked for a whole bunch of stuff that I don't think is appropriate.
But the number, it doesn't mean anything to me. It's the effectiveness of what they're asking for. Okay, got your response. Okay, from the defense side, what is it that you need that you haven't gotten that you think is so critical right now?
Well, so I've got an entire motion to compel that I'm going to file this week, Your Honor. So I'll brief all these issues because and to say that Mr. Callahan, I've got emails from him last week saying, hey, I still owe you all this information. I'm going to get it to you. But to you, he's saying he's produced everything that he thinks is responsive.
Oh, we're going to continue to produce documents. I don't, my response was, I'm not stonewalling. We've produced documents and we're continuing our efforts to gather them. I'm not stonewalling him. He has told me he's produced everything from cross-country he intends to produce. I've not said that. So if my statement earlier was not clear, I should clarify.
Okay, understood. Let me ask one more question. And I want you to be honest with me, okay? I know you want everything, but we're not in a position to do that right now. What do you need to show a question of fact that you don't have and can't show in response to these three areas for the motion for summary judgment?
For the breach of contract cause of action, I would like to have Ryan Grubbs and Michael Cooksey's closed loan reports for the time that they were at Mid-America Mortgage, and then what I've called audit trails would show. I need some paperwork from Mid-America to substantiate my contention that they were switching commissions. I know it was happening. I know the testimony will reflect that, and I know they have documents showing that this commission shifting was going on, and they haven't given.
I kind of agree. That's what you want to present to a jury. That's not my question. My question is, what do you need to respond to the summary judgment motion? I think we've kind of discussed this, and I think a properly drafted affidavit will show a question of fact or whether or not the plaintiff breached the contract. That's what I'm thinking right now, okay? I don't know if, obviously, the more discovery you get, the more stuff you can put in the affidavit, and the better you can prepare to try that on the merits. That's not my question. So let's move on from the breach of contract. I think, the way I'm thinking now, I think you can defeat that with the properly drafted affidavit and with the contract. let's go to the FSLA deal. What do you need to be able to show that he was not exempt based upon the code? And Mr. Callahan's argument that because of the way he was compensated, he's exempt from that kind of coverage.
Well, I would like to have his submittals to MAM with respect to any overtime pay. I would like to have MAM's internal correspondence about paying its loan originators overtime pay or whether they were exempt. Shane, is there anything else that you think we need to be able to defeat this contention that he was an exempt employee?
No, that's it.
Okay, you said you want the correspondence regarding overtime pay and what else?
I would like to have I've identified a specific document. I don't know the name of it right now, but I have it in correspondence to Mr. Callahan. It's documents that Mr. Grubb submitted to Mr. Cooksey and to Mid-America about his hourly investment of time. It's called like a yearly report, and then there's a 6-month report, and I've identified those by name and asked that they be searched for and provided.
Okay, and what about the unjust enrichment? What do you need for that?
So the unjust enrichment, I would like to have, I need information, the correspondence related to MAM's recruitment and onboarding of Michael Cooksey and Ryan Grubbs to show the information that they brought with them and what Mid-America did with that information. And then I would also like to have the correspondence about Mr. Cooksey's firing, which has been promised to me. It's supposed to be here at some point, I think.
But how does that relate to the enrichment?
So, what I'm looking for specifically is the benefit that was conveyed upon Mid-America that Mr. Cooksey was robbed of, the information and the expertise that he provided to Mid-America that they benefited from that he did not, that he should have benefited from.
I understand
And so
that.
I think,
So
and
I guess what I'm trying to do, and this is where I'm leaning, is that first of all, I'm not going to continue the summary judgment motion hearing. I'm going to make it contingent, Mr. Callahan, on you providing some information to the defendants regarding the things that we've just discussed. And if at the time the hearing is had, or let's say, how much time will you need to respond to the summary judgment motion hearing once you get the information? Mr. Conley, Mr.
how much time will we need to file a written response to the summary judgment motion? A week, maybe 10 days at the most.
Wow. Well, see, this is scheduled for the 24th.
And
May I say something?
Would you like,
Go ahead,
we
Mr.
could file it
Callahan.
before that if
Let's get Ms. Callahan's response. Go ahead, sir.
Your Honor, Rule 166AG says
I
there's supposed
understand what it says.
there's no affidavit in front of you that explains why they can't come forward with the evidence that they claim to need. There's no affidavit in front of you that supports Mr. Conley's assertions about what Mr. Grubbs did and what he's waiting for. Mr. Grubbs should have filed an affidavit to that effect in support of this motion. They've admitted that they think they can create a fact issue on the breach contract issue with what they've got. The other two questions are pure legal issues. There's no reason to continue this hearing. Mr. Grubbs can file an affidavit.
I have not,
What he submitted.
I've said I'm not going to continue the hearing, Mr. Callahan, but it's going to
Okay.
be contingent on something.
Well, they haven't filed a motion to
I
compel.
understand.
I'm not sure that,
I
I
understand.
don't, how you can
Let me, well,
basically grant one.
Your Honor, under the rules, we're required to file our response on Friday, which would be a week before the hearing. So I don't know how Mr. Callahan can get that information provided to us and we can incorporate it into a response by Friday.
well, you're working against yourself right now, okay? Because I said I'm not going to continue the hearing. I'm trying to respond in a way that will give you enough information. I think you have enough now, but I'm I'm trying to give you a way where you can have enough information to make a response. Now, you can choose to do that or not, okay? I think Mr. Callahan has made a very good argument where you can present evidence to the point that you can defeat this. All you've got to do is raise a fact issue. You don't have to, we're not going to be in front of a jury on the 24th. So I'm trying to see if we can cut this baby in half and make this thing work. And that's why I was trying to ask, what do you need? Now, having said I'm not going to continue it, I'm going to let you guys see if we can work this thing out to where you can get the minimum amount that you need. And I would suggest maybe you want to file your motion to compel, Mr. Conley. I think that's probably appropriate now, since we got to this point. But I'm trying to get you the information you think you may need in order to respond to this summary judgment motion. So this is what I'm thinking. I think, looks like from what I understand from you, Mr. Conley, the information you need is fairly narrowly tailored. You need information regarding overtime pay and documents that your clients are required to submit when they are spending hourly investments on a file. Okay. And I think you said you wanted information about how they were recruited and what they were promised when they brought their caseload or their clients with them to respond to the unjustly enrichment counterclaim or the motion for summary judgment against that. I think you already have enough information for a breach of contract. So my question to you, Mr. Callahan, and I understand your position, and of course you're more than welcome to appeal this to the sitting judge. When would it take you, how long would it take you to get those narrowly tailored requests to the defendants?
Well, as I stand here today, Judge, I don't know the answer to that question. We have some documents that our client is in the process of gathering and/or has already sent to us that we haven't finished looking at. Some of them may be in there. The problem, and I've already told them that when we find some of these documents, we're gonna go produce them. The problem is, I've made some objections to what he wants. These people were recruited 10, 12, 13 years ago. He's asked for every single communication with respect to them. I've made objections to that, and I, with all due respect, don't think you should essentially grant a motion to compel and overrule objections I have made when that motion to compel has not really even been filed.
I'm not addressing the motion to compel.
Okay, but I think effectively that's what you would be doing if you
Well,
ordered me to
no,
do anything.
I'm responding to the defendant's response to your summary judgment motion that they don't have information to respond to the summary judge. That's what I'm ruling on now. I'm trying to get them what they need to respond. Now,
All of that went to their breach of contract counterclaim, Judge. Mr. Connolly said he has enough evidence to submit an affidavit that responds to the motion. I would ask you to let motions to compel be resolved in the ordinary course.
okay, this is what I'm going to rule on, guys, and you're more than free to take this to the sitting judge. I think it's I'm not sure who's
192nd.
sitting there. I'm sorry.
We're in the 192nd.
Yeah, well, I think Judge Jordan is sitting in that now, so you're welcome to, when we finish up, just get on the phone and say, I want to appeal Judge Hurdle. He spent an hour with us and didn't do anything. And maybe he'll rule differently, but this is going to be my ruling. One, I'm not going to continue the hearing. Two, I'm going to order that the plaintiffs provide, and any and all, I know it's overly broad, and we're looking at a week away, so I want you, and I don't know, Mr. Conley, if you need everyone. I think if you only get one of these documents, I think it'd be sufficient to support it with an affidavit about correspondence to these individuals regarding how they handle overtime pay, and any document that they have requested to the plaintiff regarding any hourly investment of time on a matter. And
Well, there's only one person who's making that claim, Judge.
okay,
so-
well, it would only apply to that one then, okay.
All right.
And then the correspondence, it don't have to be any and all, that related to how these gentlemen were recruited. And more specifically, I want you to understand, Mr. Callahan, were they told to bring in clients and their book of business, or as it were. And I'm going to ask you to get that to the defendants. Today is the 13th. I'm going to ask you to get that to them by the 16th. That's 3 days, really 4 days if you continue today. And then I'm going to ask that the defendants file their response by the 21st. That's 3 days before the hearing. If at any time, and we're not going to argue over the sufficiency of what was produced, because I think that'd be a waste of time. Because like I said, all you need to do is produce one fact issue. But in the event that the plaintiffs do not provide this, then my notes will indicate that the hearing will be continued. And we'll take up the other issue about all the other discovery issues and those concerns that are still outstanding.
Your Honor, should I submit a proposed order with those terms, or are you going to write that into?
Well, I usually like the parties to do that, but since I've been kind of overzealous and I think this order should read, I'm going to generate it today, and it should be available for everyone later this afternoon. But in spite of the order, I want everybody to understand the spirit of what I'm trying to do here. And I want everybody to make a good faith effort to abide by that. And with the idea that you only need one fact issue, and it looks like from what you're asking, you can probably present that with the evidence that, with the material that I'm asking Mr. Callahan to provide. And if you can't do it with that, then we'll hear the motion for summary judgment.
Thank you, Judge.
Anything further?
No, Your Honor.
Thank you for your time, Ronald.
All right, thank you very much. You guys may be dismissed.